visible, but I'm just thinking about like would I knock it off? Okay, let's go with the left pocket. Not yet. Ready?
So far.
Awesome.
That's a really good start.
Excellent. Okay.
That's for the most part show level. And then, are you going to be a show talk?
I'm a litigator, so you will hear me.
I like that. All right, you're done.
I'm a litigator, so you will hear me. Also pretty good. Hello, hello.
Excellent. Ladies, you are both open. Talk to each other.
Hi, good morning. That is very loud. It'll be great.
I've got both of you.
Hello, hello.
Awesome. Ladies, you are both open. Talk to each other.
Hi, good morning. That is very loud. It'll be great. Hello.
I'm good, thank you, though. That's very kind.
All right, welcome
Okay,
everyone.
so we're starting. I'm gonna scroll
We
down.
have had a really exciting set of sessions over the past few days. We're on our final day, and we have even more exciting sessions. So yesterday, we had a number of keynotes and tutorials and craft sessions that were well attended. We have a couple of reminders as we go into this last day. So first of all, a quick reminder that we have all committed to the FACT community agreements in terms of our own conduct and behavior and how we relate to each other. So if you feel that you need a refresher on that, feel free to go to the link listed there. Essentially, we have committed to interact with one another with a great deal of respect and respect each other's privacy and space. So if you have any questions about that, you can come to any of us over the course of the conference. And if you have feelings that the community agreements have been violated in any way, you can also reach out to us. There's an email address at that link for you to do so. There's also time to review and sign the FACT statement on AI harms and policy. The link is also listed. We heard from Michael from the EC yesterday about that. And then we are closing out the day with a town hall where we'll kind of walk through different features and new additions for the conference this year. And the ECs will kind of make higher level comments about the direction of the conference in general. Yeah.
We do encourage you all to come out to the town hall. It is a space to give feedback, to hear about the progression of FACT. As you know, FACT is still relatively younger conference, and so it would be really great to learn about how we've progressed since last year and what we're trying to do for next year with you all's input. So we really do encourage folks to come out to the town hall this afternoon.
Right, and the discussion from last year directly informed how this year was run, so it does matter. Aziz? Yeah. So this afternoon we have a really exciting keynote with folks from the Invisible Institute, so Trina Reynolds-Tyler, and then Tariq Shah from the Human Rights Data Analysis Group. And they'll be talking about a project that they have done using machine learning for policing oversight. And so that's this morning at 4, directly ahead of the town hall. And this is a new format in the past couple of years. It's a community keynote. So it's a keynote led by and given by folks within the advocacy space, and we're really proud. It's at least something that I'm very proud of, and I think the other chairs are, that we've been able to do this. And so your attendance would be appreciated, and I think we'll all learn a lot.
So we're delighted this morning to have as a final morning keynote, a conversation between Sorel Friedler, who many of you know from Haverford, and he's been on a number of panels and was very involved in the AI Bill of Rights' creation, gave a wonderful tutorial about that earlier in the week. And Charlotte Burrows, who is the chair of the US Equal Opportunity Employment Commission. And I'll say a couple of words about Chair Burrows, and I'll say a couple of words about the EEOC, but Chair Burrows is going to explain why this is a body that has great relevance to the work that many of us in this room do. So Charlotte Burrows is a graduate of the Yale Law School and has got on to an immensely illustrious career in public service in the federal government. She worked for Senator Edward Kennedy, and in her time with Senator Kennedy, worked on a number of tremendously important pieces of legislation, including the Americans with Disabilities Act and a statute called the Lilly Ledbetter Act, which concerns equal pay without gender disparities. She's previously been the she's previously been the Deputy Attorney General in the US Department of Justice, which is responsible not only for criminal matters that you see on television, but the enforcement of many important civil rights laws. And those were the domain that Chair Burrows was responsible for at the Department of Justice, matters like voting rights, employment litigation, addressing racial profiling, and implementing the Violence Against Women Act. In her role as chair at the EEOC, Chair Burrows has focused upon the extension of the federal protections for employees to vulnerable and marginalized populations, particularly Native American groups and non-citizen populations. But it's also relevant to us, thought deeply and hard about how to ensure that the regulatory, the legal framework for fair employment keeps up with changes in technology used in hiring. The EEOC, and this is something that the chair will say a little bit more about, is the principal agency responsible for not just enforcing the fair employment laws, laws that govern pay equality, that address harassment in the workplace, and many other ills around employment. It's also been a path-marking body carving out and leading on understandings of what it means to have a fair workplace. And that's been true since the 1960s, when the agency took the lead on issues about gender in the workplace and what does it mean to be treated disparately. So we're delighted to have Chair Burrows in conversation with Sorrel, talking to us about how the EEOC is addressing questions of new technologies in the workplace. Thank you so much.
Good morning. I am not a morning person, but I am so excited to be here. And really am thrilled that this is such an important time that I'm able to join with you on this convention in particular. And wanted to say a few words. I think the first thing I'll say is that I actually was Associate Deputy Attorney General, so not Deputy Attorney General, who was my immediate boss. I have to make that correction, or I'll hear about it when I get back to DC. And I'd really like to thank the conference organizers for the opportunity to speak with you as we approach these issues of artificial intelligence and how to protect civil rights, which has really become a new civil rights frontier. So, as you have heard, I'm the chair of this EEOC, the Equal Employment Opportunity Commission, and my background is as a civil rights lawyer. And what I want to talk to you about, though, today is not the law per se, although I will share some of how we are approaching our work, but really about how the work that all of you do and that we do relates to our fundamental democratic values, our fundamental values as a global community with respect for human rights and justice and fairness and equality. And before we dive into that conversation, I want to give you a little bit of an overview of our work, very practically, but also situated in that really important space of our democratic values. So I'll start at the beginning. The EEOC was founded in direct response to the March on Washington for Jobs and Freedom. We were the jobs part. So that was 60 years ago in the United States. Americans, and some who I think were probably not citizens, came together in the nation's capital to demand equality in the workplace. And that was at first a call immediately for the end of the racial segregation, our own racial apartheid here in the United States. Jim Crow laws, I saw you've got another panel talking about that. And the marginalized and unobserved American populations, but the statute also covered other bases, including sex, and that's interpreted to include sexual orientation and gender identity, age, disability. Eventually those were added. to our statute, our statutes rather, and as well as national origin, genetic information, most recently, color, and of course religion. And so since we opened our doors in 1965, our one mission has been to prevent and remedy discrimination in the nation's workplaces, however that may be manifested, however it may be done. And so we are, as you heard, the primary federal agency charged with this, and we are trying to ensure that all employees in the United States have those protections. As a point of framework, we have a variety of tools in our toolbox. We use, for instance, outreach and education, public forum interaction like these. But we also have investigations and litigation in our toolbox. Those are things that we do as a regular bread and butter. And so just to give you a sense of that, last year we returned somewhat north of $500 million to American workers who had experienced discrimination. So that money doesn't come to us, but it goes back to people who lost wages because they were fired unfairly, or who had, been sexually harassed and had to be compensated for the pain and suffering that goes with that. So all of those issues are in our bailiwick, and we try very hard to think forward and prevent and educate first, so that we use the litigation tool when it's necessary. But obviously, it's much better for the worker, it's much better for the society if we never get to a situation where we have to go to court at all. So that, in a nutshell, is what we do. Why I am here is because it is so important as we look forward in our work that we're nimble enough to address discrimination in whatever form it occurs. And so those laws that I talked about that we enforce, all of which, if you look in the statute books, if you look back at the history books, each one of them was passed with broad bipartisan majorities. Even right at the beginning, although it was controversial, the nation was going through such racial strife in the 60s, right? But we got broad bipartisan majorities, partially because you had to get over the longest filibuster in history, that is true, but we did it. And most recently, in December of 2022, we got our most recent statute, also broad bipartisan majorities, in the House and Senate, the Pregnant Workers Fairness Act, which I'm happy to say we're working busily to write the regulations on that. But in between, if you look back at the Americans with Disabilities Act, the Little Ledbetter Act, you're seeing robust bipartisan majorities because there is a broad national consensus that we have to protect civil rights. And in my conversations with partners in Europe and elsewhere, I think I can say there's a broad international consensus that we have to protect civil rights. And so the reason I wanted to talk to you about that is we've got to be able to do that in the context of AI, in the context of the ways in which employers are starting to use that. So I started a algorithmic fairness initiative in 2021. Automated systems and algorithmic fairness, AI, right at the heart of what we need to be thinking about with these, some of them relatively old statutes, but they are robust and they still apply. And the challenge for us is to make sure that we're nimble enough to spot the issues, educate, and address those issues. I think there are a lot of folks of goodwill as they look at these programs are thinking about, and I count all of you in this who are listening, how do we do that in a context where we've got emerging technologies? As you all know, increasingly, AI and other automated technologies are being enlisted and affecting all of our lives in so many different ways, including in employment. And what we're seeing is that AI and automated technologies, other than predictive AI, generative AI I think is not, generative AI I think is not really being deployed yet in the employment context yet. But by some estimates, as many as 83% of employers and up to 99% of what's called the Fortune 500, so our largest companies, are using some form of automated tools to screen or rank candidates for hire, employers are making employment decisions also on the basis of, so besides recruitment and hiring, once you get in the door, there are surveillance, surveillance and monitoring is going on. You see decisions about assignments, decisions about promotions, decisions about even who to fire or lay off being in some ways influenced by automated technologies. So throughout the life cycle of employment, and the real civil rights harms that can come from these tools if they are not used appropriately and with guardrails which exist in the law already, if they are not used in compliance with them, we can see that it will unfortunately lead to a high-tech pathway to discrimination. And what I mean is that I'm sure each of you has read or heard about the, instances of, say, a resume screener that omitted women applicants uniformly because they had things on their resumes like women's sports, or maybe a women's college that wasn't present in the training data that had been used to design the system, or a system that preferred males named Jared who played lacrosse for whatever job it was looking at. That's a real thing. You can look it up. That's likely the tip of the iceberg, honestly, if we're not careful here. And they're increasingly becoming the norm in the workplaces and deserve our attention collectively. And so what I thought was the magic of our conversation today, in addition to the chance to talk to Sorrel, was that I could talk to you a little bit about what we're seeing and how it maps onto the kinds of things we've been doing for years in our investigations and are seeing now, and hear from you about what you think are the ways in which we should be thinking forward. Hear your questions, because that will help me know if we're on the right track, and also bring some very practical, day-by-day civil rights perspective to what is of necessity an academic issue, because of necessity a somewhat divorced from the day-to-day of most people's lives, because we're talking about technology that a lot of people don't deal with on and off. But we have to bring those two things together. And so I hope that our conversation will do that. Just a little bit about our Algorithmic Fairness Initiative, what we're doing at the EEOC in addition to our usual bread and butter investigatory work, et cetera, is to try and mostly educate ourselves, but also the public about our laws, educate ourselves about what you all are doing and about where the technology is going, and make sure that we are in dialogue with those about what the legal obligations are as those technologies developed. We issued two technical assistance documents that I think are really important to flag today so that you're all aware. The first I want to talk about has to do with our main statute, that statute that came directly out of the Civil Rights March, which covers race, national origin, color, sex, including sexual orientation, gender identity, religion as well. And what that document does is to explain how the statute works with respect to some of the issues that come up with these automatic technologies. And in particular, and I won't promise you it's too early for a legal treatise. I will be quick about this, but it's important to understand. We have two concepts in that statute. The first is disparate treatment, which is what most people think about. So the intentional disparate treatment, fill in your favorite horror story. In this instance, it is not where most of the action is and not what we talk about our document, although I will say, because I think it's important, we have on occasion found instances where, and so the disparate treatment, the intentional discrimination would be actually programming to make sure that you do not hire people of a particular race, national origin, etc. And we have, that is rare, at least I hope that's, as far as I can tell, it's rare, but we have at least one lawsuit where that was the case, dealing with age. It was basically excluding everyone's, if you got, your birth date was past a certain year, you were not going to get the job. In fact, you were not going to get considered for the job. So you were automatically rejected without a human ever being involved, which is clearly illegal under the Americans' Age Discrimination in Employment Law, Employment Act. But more typically is disparate impact. And so what I mean by that is an unjustified weeding out based on one of these protected characteristics. And we have something in place that has long guided the analysis called the Uniform Guidelines on Employee Selection Procedures. And I know that is not the sexiest title, but the content is still very, very relevant. And what we did with this technical assistance is to try and make it a little simpler and easier for folks who would not necessarily pick up something, like that, and even maybe look at the Uniform Guidelines and read them from beginning to end. And the document really talks about one thing in particular that for those of you who are thinking about disparate impact in the context of AI or automated systems, really, I hope if there's nothing else that you take from this, that you think about this. Embedded in the 1978 guidelines is something called the 4/5 rule, which basically says, it's a rule of thumb, if you will, as to when you should start considering there to be a problem of disparate impact. And so under the statute, if you have disparate impact, then you must show as the employer, not the employee, the burden shifts to the employer to show that a particular, if it's eliminating a particular group disproportionately, and statistical significance is there, then it's legal only if it's job-related and consistent with business necessity. So at that point, the employer needs to get under the hood of whatever automated system it has and show that this is actually valid, and there's a whole science that goes into how to do that. But the first question is it having that disparate impact? And the 4/5 rule has been used as a rule of thumb appropriately. I think everyone should be starting there, but it is not the only thing that is relevant here. And so I think what's been getting lost, and I really want to emphasize this, is that this, essentially what it does, by the way, is it's a check to make sure that the selection rate for any particular group, say women, is not less than 80% of what it is for men. So that if you're seeing, you're getting 28% of women are getting weeded, or getting through this selection device somehow, or 90% of women are falling out and 100% of men are going through, you've got a problem. Or even here we're saying 80%, you need to look closer. If only 60% of women can somehow get to the next step in your selection process because of this use of AI or whatever it is, you need to take a look at it, and that's what the rule of thumb is. But it is a rule of thumb, so it's a check that employers have long been, on notice that the federal government, it's an EEOC document, joined though meant to be used by all of the employers all of the employment agencies that enforce these laws. So the Department of Justice as well, the Office of Federal Contract Compliance Programs at the Department of Labor. All of us look at that, but what's important not to get lost is that this is just a standard that is the beginning of our federal investigations, if you will. It is not the end of it's not something that one should look at it, pass the 4/5 rule, particularly if you're talking about training data as opposed to an actual selection, and then move on. So some vendors have been claiming, it seems, that there's no bias as long as you can have an algorithm running that does not harm the 4/5 rule and whatever data that they've been using. So in other words, it's something that we have seen talked about as a bright line as opposed to a rule of thumb. And so that's really the essence of what we thought was an issue and what we talk about in that technical assistance guide. The guidelines themselves make clear, and I want to quote this, so bear with me, it'll be quick. A selection rate for any race, sex, or ethnic group which is less than 4/5 of the rated for the group with the highest rate will generally be regarded in the by federal enforcement agencies as evidence of adverse impact, only generally. And it goes on to say that there are a lot of situations where that will not be the case. And so, in particular, smaller differences in selection rates may nonetheless constitute adverse impacts, where there's significant in both statistical and practical terms. And so once we find statistical significance, say in an investigation, we then go on, and by the time, if it ends up in court, we are using something much more sophisticated and talking in terms of regression analyses and standard deviations. And the courts themselves have actually pointed to, the Supreme Court has actually said, in general, 2 to 3 standard deviations will be considered a measure of statistical significance. So it's really important to understand that the 4/5 rule is necessary but not sufficient. So that was pretty deep dive. Let me come back to the broader picture for a minute. We also have, and I think this is really interesting, and I'm very proud of the work that my colleagues at the EEOC did on this document. We also have a technical assistance document that looks at disability. Because disability, everything that I've said, or most of what I've just said, you can sort of move away from for disability. It works differently. It's not about the number of people and the statistical comparisons, right? If you have one blind person who cannot read your test, it doesn't matter. You don't have to get a bunch of folks. You know right away that you've discriminated by insisting on a written test, right? To be really simple. So you can screen out that person, and you have discriminated based on a disability. It's not a statistical matter, it's just a fact. So figuring out, it's really important to figure out how to make sure that whatever the employment selection device, et cetera, or any other automated system being used in employment allows for accommodations for someone to, identify that, and is really, ideally, would have alternatives that could be anticipated, because the concerns there are different, and we walk through that in our disability technical assistance guidance as well. So I commend those to you, and I want to emphasize that I've seen a lot of these conversations kind of focus on race and sex, because those are obviously important, but come up more often, but less so on disability, on age. We are looking at the whole panoply of the laws that apply to us. And we'll talk some more about how they can pop up in other areas, including surveillance, including religion, including all of our protected bases. I will stop there, but I think that what I would want to leave you with and sort of frame as you keep in mind, as you listen to our conversation, is that, as I said at the beginning, these are democratically, not just requested, passed statutes, but statutes that passed with a robust democratic process where people across this country felt so strongly that they demanded a solution, right? Came to the nation's capital, stood in August heat, which I don't know if you've been to DC in August, but it is a really big deal to stand out there all day. And so we cannot allow them to be eroded or lessened by what, and of necessity, is a very undemocratic process with experts with a high degree of expertise in and I don't mean this in a pejorative term, but the fact is, without most people having a clue what's going on, to somehow erode those democratic statutes that represent all of us and our national consensus for civil rights. So that's ultimately what we're thinking about at the EEOC. I look forward to chatting a bit with Sorrel about all the rest of it.
Thank you so much for that, Chair Burrows.
Thank you.
And I just wanted to say it's such an honor to have you here, and it's so exciting to see the issues that so many folks in this community have worked really hard to try to highlight be taken really seriously.
Is it?
Am I okay?
Okay. Is it mine?
Sorry, technical difficulties.
It's always me. I'm always the problem child. Okay. Just a minute.
Thank you.
Great. So I'll open it up to general questions in just a minute. So please also, think about what questions you have for Chair Burrows. Our hope is that this can be really a sort of collaborative discussion and, thinking about paths forward, right, as we all try to support this important work. But I wanted to start by asking you, the EEOC has obviously been conducting these types of audits and investigations for decades now. And there's many folks in this room and in the broader community who are really interested in trying to figure out, what is the right way to conduct an external audit of a technical system that has real civil rights impacts. And so I'm wondering if you could just share a little bit more about the process that you all go through, with hopes that that can inform this broader work.
Sure. Okay. I take it everyone can hear me. So a couple things. Okay, great. Thank you. Yes. Well, what's interesting is typically our investigations would start with someone coming to us. There's a whole process, which is you file what's called a charge of discrimination. And in this context, one of the things that sort of keeps me up at night a little bit is that this is a process where people don't know why that they got screened out by an algorithm typically. On some of the surveillance kinds of things, which I hope we can get to later, what's called bossware, I guess, in some contexts, people may know, but in the hiring context, which is most of where the action is, at least right now, they have no clue. So, but starting with that, what we would do is take that, let's say we have one, we're actually coming up with some training questions to kind of tease out things that might be signals for that. And we would we have the ability to ask the employer for information. So in this kind of and we have subpoena power, so they have to give us the information. But what we try to do is get to the facts. We start off in a neutral posture and would ask for, in this case, say, training data, whatever that's relevant. But I think first and foremost, information about applicants, who'd taken, if we were talking about a hiring assessment, what the applicant flow was, what the hiring was, what their demographics are, and then put that together with the information we've gotten from other places. And we also, though, often will say, let me talk to someone in your organization. We have the ability to go in and do an interview, because one of the things that I have learned in speaking with employers is that sometimes this will be looked at, like the whole panoply of how you could do hiring better, including automated systems to help hire or screen will be an HR function, and the lawyers may not be aware. The folks who are looking for civil rights checks may not be aware because they're not consulted on everything. And so you might just say, but they're usually the ones who are answering our inquiries, right? So you might just say, well, let me talk to the people who are actually doing the hiring and find out a lot that way. We have the ability to do that. And ultimately, go through the entire piece of it. We will bring in internally, we have a number of statisticians and labor economists that will look at it depending on the specific facts. And even at that point in the investigation, typically as we go further, again, we're looking at the 4/5 rule, but we're also looking at regression analyses and that sort of thing, depending on what it is.
So you mentioned this in passing. I was wondering if you could tell us a little bit more about how you all are thinking about the workplace surveillance issue, right? We've been talking and thinking largely about hiring systems, but those are a little bit different. So I'm wondering if you could say more there.
Absolutely. Super interesting. So we don't have a full idea yet of how prevalent those are. It's definitely, at least from some of the surveys from employers, less prevalent than, some of the hiring and screening tools, but definitely an issue. And an issue that I think we're hearing about, because that is something that employees notice or aware of, or at least suspect. We're seeing them in industries like where things involve, say, manufacturing, where you have a specific task that you can have an algorithm about how long it's supposed to take you. So think about, packing boxes or delivering the people who come to your door to deliver packages. How long are you supposed to take for each, for each delivery? That kind of thing, there's sometimes an algorithm. What we have started to see is that people are saying to us, that algorithm doesn't take account for the fact that I need an accommodation because I work differently. So I can do the job, but I use a hand tool, or I do this differently, or I need to take a break, and I need to take perhaps a prayer break, right? We've done cases where employers were not permitting people to, we had Muslim workers who needed to take a break 5 times a day, and that was not being allowed. Or pregnant women. I'm thinking about this a lot because we're looking at the Pregnant Workers Fairness Act, which is the new law that says there's going to need to be accommodations for basic things like sitting down. I know, you're all thinking, why did you have to have a federal law for this? To sit down when you're pregnant, or taking a water break or food break. Believe it or not, those were things that people were not being permitted sometimes in some workplaces. So Congress, and again with broad bipartisan majorities, I'm happy to say, has now said you have to do that. Well, the issue, if you're in a warehouse or you have a tight schedule, may be that you just can't do that and also meet the strict time limits that the algorithm has set, right? And the question becomes more complicated if things are so automated that it's difficult to find a way to break through that and say, I need an accommodation. If it's truly automated, it sometimes can be hard to find a person that you have that conversation with. And as a legal matter under the Pregnant Workers Fairness Act and the Americans with Disabilities Act, employers are supposed to engage in an interactive process, the back and forth, to say, hey, I can't do X, but maybe I could do this other thing that would fix your issue, right? I can't give you, a permanent work from home job, but what if we changed your modifications here and you worked from home, 3 days a week? That conversation has to happen in order to figure out truly whether or not the employer can accommodate, because the requirement to accommodate only applies if it's not going to create undue hardship for the employer. So I see a lot of people waiting, and I don't know if you want to ask, see if they have questions, or if you want to.
I have one more quick question
I love hearing your questions.
But I will try to do this quickly because, yes, we do want to get to questions. I was just wondering if you could tell us a little bit more about how you all are thinking about this across the federal government, right? Because, of course, algorithmic discrimination comes up in employment, but also in a lot of other sectors. So I was wondering if you could share a little bit about that.
Absolutely. I am a big believer in collaboration. I'm a middle child, so maybe it comes naturally. And have been absolutely thrilled that we are partnering pretty closely with other agencies, in particular the Federal Trade Commission, which is very interested in employee issues, which I welcome. And they have jurisdiction over some of the antitrust issues, as well as the Department of Justice. We share, actually, enforcement authority with them and under several of our statutes, particularly with respect to Title VII. With state and local governments, they actually are the ones that get the fun of going to court if it gets that far. We investigate, and if it's a state or local government, we would then turn it over to DOJ. So we're obviously cooperating, looking at issues very closely with them. The Consumer Finance Protection Bureau, proud to partner with them as well. And we recently got together and put out a statement of principles to make clear that we are looking cooperatively, but also very carefully at AI issues, and will enforce. I think there's a lot of confusion or at least conversation, I will say, about the fact that this is a new technology, we need new tools to, regulate. That is all true, but we also have current tools that apply already, and we intend to, make sure that we protect where the law says that we have to do that. So that was the purpose of it, but we are doing things like we each have in different ways put together working groups, ours through our initiative, and we get our working groups together. We make sure we understand each other's authorities enough so that we could then refer things and make sure that we are having those conversations so that we see where something may cross issues and we really need to look at it from more than one lens. So that has been exciting. I think it's important. And also, because this is emerging, we're trying very hard, and thank you for your work on the blueprint and all of that. It's been tremendous. And we miss you in the administration, but we understand you have other things to do. But the really important thing, I think, is that we use the same language and that we try to get enough consistency and coherence that we are clear as an administration externally. So that's not perfect because we have different laws and they have different sort of goals, et cetera, but to have at least as much consistency as possible, I think that's only fair to folks who are working in this area, to not have a sort of disjointed approach as well.
Thank you. Okay, so I want to open it up to all of you. When you come to the mic, if you could please introduce yourself to the chair, that would be great.
Good morning.
My name is Julia Stojanovic. I direct the Center for Responsible AI at NYU, and I have been really looking forward to this conversation with you, and I have, so much to say and to ask, but I'll be brief. So, I've been involved very, very heavily in New York City's efforts to try and regulate the use of automated decision-making in hiring. And one of the things that really keeps me up at night is that we are not speaking about validity of these tools. And there's quite a bit of fair washing, so to say, that goes on where vendors and employers are incentivized to show that they're in compliance with the 80% rule, and then they feel sure that they're not going to be interrogated for whether the tools are doing anything meaningful. So I just want to stress that the amount of snake oil that proliferates in this domain is mind-blowing, right? So I'm going to read a very short sentence. This is from a testimony, one of the many testimonies that I gave in New York City during the deliberations on this law. So the main point being that if a tool screens in or screens out people in proportion based on gender or race or age, but it's absolutely arbitrary, then it cannot be considered fair, right? And it shouldn't be expensive either, because you could be just doing a random coin flip and you would be getting the same result essentially. So we did an external audit of a couple of tools that claim to predict personality profiles of individuals based on their resumes or LinkedIn feeds or Twitter feeds. And we found, and so a personality profile is a bunch of numbers, right, that the tool spits out, and then HR uses it to match people with jobs. And what we found was that if you give the same resume as input to a couple of these tools, you may get a completely different answer depending on whether your resume is in a PDF format, for example, or in raw text. And sometimes it's a better outcome for you to be in PDF, and other times it's a worse outcome. So long story short, I wonder whether the EEOC or maybe consumer protection is looking at these issues. I think we need federal level laws. And I'll also just give this to you while you're responding. So this is a public education gadget.
Oh, okay, awesome. Thank you.
Where we talk about employment as an entry point into what is AI and why we should care.
In case anyone else wants to see it. Thank you. And thank you for the question. I will say that, so validity is actually the second step in our analysis. So there's first the question of is there disparate impacts? And then you'd be looking at validity. second, so we would do that, but you wouldn't get there as a civil rights agency necessarily if we couldn't find a reason that it's having that kind of a, snake oil from maybe a problem, but it's not a problem that we can solve unless it also is discriminatory. But I hear what you're saying, and I think that it also puts a lot of, pressure on us getting it right, that it's actually not, because as you say, you're assuming things based on the statistics, but maybe that it's not entirely fair because you don't have validity, but that's not something that we look at. It's interesting because I'm not sure, I'll have to just say I'm not sure if there is a federal agency that would look at that independently. I think that's more of what Congress may or may not have to decide. Do they want to create? The broader issue, I think, though, is really valid. Like, what exactly are we doing here? And so I applaud that focus because, there's no one has an interest in that. I mean, maybe if you're selling something that you have an interest in, but no one else does. And I think that is a really critical point to be looking at as well.
Yeah,
Sure.
I really think that we should figure out how to deal with this because the loudest voices are the vendors of the tools, and they couldn't care less whether it's valid. And it's very easy for them to pass the 80% rule screen. So, yeah.
Thank you.
Thank you.
Can I just step in and encourage everyone to be brief in their questions? There's a very long line. We only have a short time.
Hi, my name is Emily Hadley. I'm a research data scientist at RTI International. Really grateful for you to be here today. One of the topics we've been talking a lot about here at the conference is generative AI, and you touched on it briefly. And one of the topics that came up, we heard from some artists earlier this week that are really worried about their work being stolen or not getting additional work. And I think there are concerns among copy editors and even potentially engineers and data scientists about, I don't want to make it too broad, but like being replaced by algorithms or having aspects of our jobs replaced. And do you see that replacement of human workers as algorithms within the civil rights scope of the EEOC, or is that an issue that's not kind of in your purview?
So this is going to sound like a lawyer, but it depends. For the most part, and what I mean by that is jobs, create, et cetera, like what happens then to those workers? And how do we react if there is a job that's changed, et cetera? Like typically, this is just, the people with the least power in the workplace will do less well when there's like some sudden change. And so if that then maps onto, as it often does, people of color, women, et cetera, really depends on how that plays out. But that is definitely something that we're thinking about.
Thanks.
Hello, so I'm Árndís Eliasdóttir from Amazon, and I wanted to ask if the EEOC is either thinking about or has some mechanisms to tackle what I think of as sort of an industry-wide adverse impact. And what I'm talking about here is if you sample a lot of employers and all of them are small, you actually expect to see variation in the sort of success rates of candidates based on protected variables because the samples are small. But if you look at a larger sample, you expect those differences to go away. However, when you have an industry-wide issue, what you'll see is that in all of these samples, the biases are going in the same direction, so they don't actually cancel out. However, I don't think it's easy to put a lawsuit up against an industry. So do we have some mechanisms or ways for tackling this? And for example, do we think that the use of these ML tools more broadly will perhaps allow us to start getting these larger samples and become aware and have evidence to prove that these industry issues exist?
So really interesting. With this, the question of statistical sample size is something that we come up against a lot. There are some, racial groups, for instance, like sometimes there's not that many Asian Americans in a particular workplace, and you can't aggregate in any way, even if you, oftentimes we'll try to like take multiple years or multiple, sort of the same employer, multiple warehouses or whatever. It is an important issue. I'm not sure we're going to solve it here this morning, but definitely curious. And no, I'm not aware of a industry-wide per se in terms of like legally putting it together that way. But we recognize the concept. And typically what we would do is even within an industry, we'd look for outliers. Because surprisingly, even if everything's going that in a particular direction, we'd look for outliers. And that's where some of those other tools that we're talking about also come in terms of conversations, et cetera. But we don't, the last thing I'll say though, because it goes back to the very first question where we started, which is how do we do our work? We don't necessarily just look at, even when it's a big case where you know it's going to be mostly on data, we don't just look at that. We talk to people. So it may be that you don't have enough people in the numbers, but when you talk to them, what are they going through, right? And what happened, or how many people didn't apply because they know they never get through the door. When you have those conversations and talk to civil rights groups, sometimes you will find that actually you could put on a case with witnesses who said, yeah, because they said we don't, and sadly we had a case, still have cases. The most recent one I think was we filed last year. We don't hire women. People still say that, it turns out. We don't hire women. So yeah, there was nothing in the statistical sample, but we were still able to get that one resolved.
Yeah, hi. We got a question from online audience. So it seems as though the fifth or fourth rule has become a de facto compliance target. I worry that the net effect of the fourth or fifth rule is to ossify or codify disparate treatment of marginal groups. How do you address the market-wide effects of a rule like this? So I think it's the fourth or fifth rule.
Four-fifths rule.
Yeah.
It's about the fourth-fifths rule, and you said, I'm not sure I caught all of it with respect to, is that such, in other words, I think, let me repeat this and tell me if I got this right.
Yeah, sure.
I think the essence of the question is asking whether or not the fourth-fifths rule, because it says, okay, not more than 80%, is sort of presuming a ceiling, right? Presuming that women shouldn't be 90% in that. Is that essentially the essence of it? Is that actually, and I think that is a worrisome thing, particularly because you may not know in a particular employer, or region, et cetera, what the right answer is. So that's another reason why I say it's just a rule of thumb. But I'm really glad you raised that, because that's exactly why it's so worrisome to hear, and I keep hearing that, okay, well, you know, we can pass the four-fifths rule, no discrimination here, and we didn't, you know, not even leaving aside that the four-fifths rule is completely irrelevant when you're talking about disability discrimination, but also, you know, for the reasons that you point out. So, but there are ways, not perfect, but then to look deeper when you have reason. And that, I think, is, as we go forward in our work, and I'm really interested in your ideas in this, figuring out how to test how well the assumptions that went into, because we wouldn't stop with the four-fifths rule, and I would urge vendors not to either, but to test the assumptions that went into, well, what do you, is there a problem here? And that goes to things like, is the data that was used really typical of what you're really gonna see when you start, when people start applying? And there are, you know, ways to, there are ways to, I don't wanna say cook the books, because that has a very negative connotation, but we really have to be sophisticated in thinking about that. So I appreciate the question.
Thank you.
Hi, I'm Miranda Bogan. I've worked in civil society and in industry and looked at a lot of issues on AI and hiring. So my question is, in the context of hiring, employers are required to give applicants the opportunity to self-identify their protected characteristics during the application process, but don't require it. And if I'm not mistaken, the employment selection procedures have a allowance for employers to fill in the gaps in that data when people don't choose to self-identify, which is really critical for measurement. That's not necessarily the case throughout the employment process before people actually submit an application, and is probably limited in a variety of other ways. So I'm curious if the agency is thinking about how to broaden the guidance related to the availability of demographic data for measurement throughout the employment pipeline, and or thinking about updating the guidance in that sense, since it seems potentially outdated, or might need to be rethought in the context of machine learning, where visual observation could be interpreted to mean a variety of different things, and machine learning interpretation, et cetera.
Okay, someone who clearly did her homework. Good morning. Yeah, so a couple things on that. I think that you're right, that you might not have applicant flow data at each point in a process. So then, okay, well, how do you know if there's been disparate impact? And when I say I mean the employer might not have that information. And particularly when you think about online kinds of recruitments, one of the things we're amongst them that's kind of interesting is these recruitments that only certain people get to see the ad, right? But, or sent, oh, please apply, right? How do you do that? But so we come across that all the time, that actually is not new. That was the case in 1978 when the guidelines came out. And so it really depends on the particular facts of the instance. Can you look at, is it appropriate to look at census data? Is it appropriate to look at other sources of data and to put together a puzzle? The key to the way we think about these investigations is it's never just one thing. We also have information from our past investigations. We have information from people calling us and other interviews, so it's really a plethora of things that we're looking at. As to the guidelines themselves, I think that whether or not we would clarify, I'm getting the hindsight, whether we'd clarify it is something that we are thinking about. It just sort of depends as we go forward where we think we need to put more emphasis and maybe clarify. So that the TA was the first step to say, hey, are you reading it correctly already with what it already says? But I take your point.
Hi, I'm Xiu Lin. I work for Capital One. I'm in talent acquisition or recruitment, and my specific role is to look at AI's usage in recruitment. So I wanted to ask a question about how to strike a balance in using AI and also the regulation itself, right? Because we are witnessing a lot of difficulties in recruitment currently in vital industries like hospitality, healthcare, retail, right? So employers in these industries are increasingly relying on AI vendors to bridge that gap, to help them find employees, and they're increasingly relying on AI vendors to basically provide the full life cycle of support from sourcing all the way to hiring or onboarding, right? So in considering this trend, I'm wondering, is there a balance where we can strike, where we help these companies find employees faster, right? Like the solutions that the AI vendors are offering, but also protect the workers' rights? And what do you see as a possible equilibrium in this context? And are there any historical precedents in EEOC's history that we can borrow lessons from?
I want to think about the last one a little bit. I would say just quickly on this, there's so many different contexts. The key has got to be context specific. So I can't, even if I had some crystal ball, like, oh, here's the perfect equilibrium, it's not the same thing in everything. And every employment situation is different. But the key, I think, will be to make sure that there's not, there's all this conversation about the human in the loop, right? That there needs to be someone to think about those. If you're just first weeding, I have so much sympathy for people who are trying to either weed out or bridge out to get that applicant pool in the first place. So if you have too many applications that you just could not humanly look at them. So to figure out that, but then when it comes to the high-stake consideration, to really, I think that's where it's very, very important to think about what assumptions are moving people from each step to the next step. And that will differ in every instance as to what it is you're looking for. But there's a whole IO psychology, decades of experience and expertise that has been developed, and the Society for Industrial Organizational Psychologists have looked at this in more detail. So I would commend to you their work, because it's not like we're writing on a blank slate. There are decades of expertise about how to do job selection well. And I think we can borrow from that and then apply that going forward.
I'm very sorry to cut short this terrific conversation. And I apologize that we have to bring the keynote to an end to keep everything moving. I hope that Chair Burrows may be around for a few minutes and have a chance to talk to some people who are still have questions. There's coffee, et cetera, outside if that helps. But would ask you now to join with me in thanking her for such a terrific.
Thank you. It's been a pleasure. You've been absolutely wonderful.